There is no such identifiable suable class to at all maintain a complaint. So jurisdictionally, the complaint would not be maintainable is going to be my second set of submissions.
But that will decide in the appeal.
No, these are all under 389.
389 only we have to see the suspension, why the court has not suspended this.
Correct. Now, one of the tests of your lordships for suspension, one of the tests of your lordship for suspension is that a prima facie case, a very strong case.
Appeal is pending before the consent trial.
Well, that will always be the case in 389. Correct.
Yes.
So your lordship
only 389 is, and against that order you are preparing the revision application.
My lord is right.
So we have to see just 389 only.
Well, only two things. In 389.
Go into the main proceedings, which is pending before the lower appellate court.
With one caveat, with great respect. Then, Malus, a very, very important last point would be the irreparable, irreversible nature of the Malus consequences. Malus, why is at the end of the day 389 made? 389 is made because your lordships have certain, and in this case more than any, extraordinary consequences of conviction.
Yes.
So what was the first case which is mentioned in para 5?
Yes.
That case is a case of life sentence, admittedly. Please note that it's a case of life sentence.
Yes.
Therefore, that case is a wrongful, inapposite, incorrect citation by the learned sessions court to deny me bail. It appears to be a clear error by the learned court below by applying 6 pages of judgments which apply in the reverse in my favor. Now just see the quotation at 63, and these are not quotations, they are underlined by the judge, as the lordship has noticed. So that obviously the basis of his judgment is these underlinings. Is a 332 case that is hurt to a public servant. Actually, it's a more serious case. On duty, I go and slap somebody. On duty, I go and assault somebody. So it's a fairly serious category. 3 years and etc. 6 is a very interesting irony to it. 6 is Prahlad Lodi. Prahlad Lodi is a case of hurried disqualification. I'll read that in a minute. And in this case of Prahlad Lodi, the conviction is on 31/10/2019, 31 October 2019, and sentence is on 4/11/19. Disqualification order is on 2/11/19. 2/11, that is 2 or 3 days later. And appeal is on 4/11. In my case, my conviction is on 23 March 23. And the disqualification order is 24th of March. There is no way anybody can file with supersonic speed unless we just throw papers at your lordship without filing a proper appeal in one day. He has adverse consequences. He also gets a 389 suspension. But in the case of an MP MLA, it is purely on the face of, by the nature of the whole issue, it is irreversible. It is possible that for him, it may be slightly reversible. Look at the nature of this. Then, take the other example. Suppose this continues for 3 months or 4 months. There is an established election commission circular that you will not keep a constituency unrepresented. There is no power on earth. Even a lordship's mandamus can't say, Rahul, you vacate your seat and Singhvi will come back again. No power. Nobody can say that. He's elected. And I have not stood against him. So I have not lost. No election petition can unseat him. No election petition can install me. Well, these are balance of conveniences. For what? For a murder I've done? Well, have I put my hand in the till and have been corrupt? Have I murdered somebody? Have I assaulted somebody? I've done defamation allegedly on a first appeal. In the case of a person with special adversity of disqualification, it can never be given. Because it can't be given disqualification. When can it be given? I can't think of any case where lordships can give it. It is only 2 years which will incur it. Now, keeping that in mind, come to
section 8.3 of the People's
8.3. So, maximum punishment for an alleged first-time offender in a non-cognizable case, in a bailable case, should effectively make him lose his seat permanently, irreversibly. About disqualification, his interest is that this crime is prosecuted, it is brought to fruition, somebody is convicted or acquitted, somebody is sentenced. It is not that after that, my lords, don't give Mr. Singhvi stay of conviction so that he is disqualified. That can't be the role of a complainant, brothers. It is between the court and me. I can understand that. In a rare state where there's a murder, it would be between the state and me. But brothers, how does a complainant get any locus to say, Mr. Singhvi is convicted, I'm happy. Mr. Singhvi is sentenced, I'm happy. Mr. Singhvi's sentence is stayed, I have not objected, at least for the time being. But I will object. Because Mr. Singhvi must not only be sentenced, but he must be disqualified also. Before that, there was no such kind of trust. It is true that there is no government record belonging to me showing my community as Modi. It is true that Modi's surname is found in various castes and communities. It is true that Modi's surname is found in various castes and communities. It is true that Modi's surname does not mean that it is a certain community only. It is true that except Exhibit 30, I do not have any other documentary evidence to show that a community is existing in the name of Modi. Now, 30 is what, Malas? 30 is a letterhead, blank, of the Mod Samast Gujarat Mod community.
They are just saying that
There is one typographic error in translation, it appears.
Oh, I see. Very well.
એ વાત ખરી છે કે મોઢ ગાંચી તથા મોઢ વણિક સમાજ એક જ હોય તેવું દર્શાવવાનું આદમ 1988 માં ને ભૂતવાલા સરનેમ બદલીને મોદી કરેલી નોટ મોઢ.
Very well. No problem. No problem. It is true that except Exhibit 30, that is one of page 35, it's a very important sentence. I do not have any other documentary evidence to show that a community in the name of Modi exists. But what is a 30? Exhibit 30 is a letterhead of a trust he created in 2015. A blank letterhead. Obviously, letterhead. Further compared the persons having Modi surname, thieves, and the complainant is also having the surname of Modi. Just pause here. The defamation of the Honorable Prime Minister is not involved because he is not a complainant. Certainly, he is an identified person. The next sentence is the defamation. And further compared the persons having Modi's surname and the complainant is also having surname of Modi. That is 1 out of 13 crore people. It is that which is defamation. That can't be identifiable class. Moreover, now this moreover is completely unnecessary. It's completely surplusage, conjecture. It's irrelevant to the law of defamation we're discussing. Completely. This would be relevant if I said Mr. Purneshwar Modi by name. It would be relevant. Contents of the electronic documents as having not been proved. In this regard, an ex-chair giving the details of the petition. Lordship remembers 4th of March, he went to the High Court. He said to confront me with all that. High Court, that matter was pending. The trial court had said, no, we can't confront. It is therefore crystal clear that the documents referred to above have not been brought on record in accordance with law. I may be guilty of exaggeration, I may be wrong, but I am putting it to your lordships. 1. Is it a serious offense? My answer is with great respect, the answer must be no. It is nothing in the nature of murder, rape, abduction, 5 years, 7 years, 10 years, life in prison. Number 2, is it without being a so-called serious case, a case of moral turpitude? That would be corruption, maybe some degrees of sexual offenses or other things. No, this is admittedly not that. 3, is it an anti-societal offense? Well, there may be, I can't think immediately, but there may be beyond these two categories, something which really creates, I would say, for example, creating enmity between sections. It may not have that much of 153A, etc., but it has a great societal impact where the interest is not only of Mr. Rahul or me, but is of the state to maintain an order, law and order. Therefore, that also, I'm not that. Number 4, is it a non-cognizable and bailable? Well, clearly. Number 5, is it one which can only lead to simple imprisonment? It's only 1 out of 22 such. They have hundreds of offenses, only 22 such. Number 6, these 5 are enough to stay conviction. But here, per se, there is a 6th ground. And I submit that per se ground is sufficient. Per se ground is, you are a legislator, yes. Will you lose your seat? Yes. even while you don't lose your seat and before a new election is held, will you be able to attend parliament? No. Will you lose your seat after 3 to 6 months? Yes. Will the new man who comes be liable to be reversed and you reinstalled if you win your appeal in 9 months? Answer no. Malas, what better case then can be for getting a stay of conviction when the consequences of non-stay of conviction are so drastic?
If you
No,
come-
subject to a lot
Yes,
of
because now we are having only 10 to 11 matters. If-
We would
So
prefer
after that, we
2:30.
immediately
I don't
start
mind, I
this.
don't mind.
If your lordships can
You're
consider
coming from-
2:30.
2:30.
I mean afternoon session.
Yes,
Lord.
Tuesday afternoon session.
Yes,
Please,
second half.
Obliged. Very deeply
Second.
obliged. Very deeply obliged.